Good afternoon. Hello. Please take your seats and have a little silence so we can get going. Thank you. My name is Martin Kenney. I'm from the British Virgin Islands, and we have to present to you this afternoon the subject: you cannot run a Ponzi scheme without a bank. The victims strike back. So this is a subject where we're going to lay some foundation about what a Ponzi scheme might be in relationship to suing banks for facilitating frauds of this nature. And we have to my left an excellent panel. The far left, to my side, right on yours, is Yves Klein, a colleague from Geneva, Switzerland, and fellow FraudNet member and colleague on the Stanford file, where Yves will, I guess with Switzerland, we have to be very cautious about what Yves says about a live file, so maybe he'll speak in hypotheticals that are remotely related to the Stanford case. Next to Yves is CAYLOR. Lincoln is a colleague and FraudNet member from Toronto at Bennett Jones, and is the lead on our Stanford International Bank versus Toronto Dominion Bank $5.5 billion damages claim for negligence and knowing assistance in getting compliance wrong over an 18-year period, allowing $10 billion of victim monies to pour through the bank uncritically. And then next to Lincoln is GONZALO, ZEBALLOS, who's with BakerHostetler in New York and sits in the seat of managing the international litigation brief for the trustee in bankruptcy of the Madoff fund, Mr. Irving Picard. And next to me, to my left, is Chuck LICHTMAN here in Fort Lauderdale. And Chuck was the lead for the trustee in bankruptcy in the Scott Rothstein fraud bankruptcy and his law firm. And we'll go through now some comparative charts to show the nature of the four cases that we're going to talk about briefly. The economics of a Ponzi scheme. How do they perform financially? This is crucial to understanding how to sue banks. What are their sources of cash? What are the uses of cash? What do we mean when Ponzi scheme claimants lawyers refer to redemption payments or scam interest payments? We group these together, call them Ponzi payments to fuel the Ponzi, and that's where much of the cash goes. How is this used to foment victim interest? What percentage of the scheme is used by the fraudster to pay commissions to bird dogs and operating overheads and administration, because it's a business? How much of the net profits are siphoned off or stolen by the fraudster? And you'll see some differences between four major cases of recent history. Firstly, in the economics, we have cash coming in. These are total payments by victims. US dollars, Stanford 10 billion, Madoff 20 billion, Rothstein 1.6, Peters 31.1 billion, which is just a massive sum. You'll see a lot of churning in Peters because, interestingly, the loss figures change dramatically. Net capital losses, Stanford is about half of the money taken in. Madoff is almost equal to the money taken in. Rothstein is about the same. Peters, look at Peters. The losses to victims are only $2 billion when the cash coming in the fraudulent enterprise was 30 because of churning. We're going to look at churning in a second. So where does the cash go? On Madoff, 20 billion comes in the door. I need to qualify the 0.2 billion stolen by Madoff. It's a rough approximation that we can't put on BakerHostetler, so if there's an error. But in broad terms, I think it's approximately correct that Madoff took a very small sliver in terms of the total value package represented by the fraud. You'll see 17.6 billion in Ponzi payments pushed around to victims in redemption payments. So this is what, unsurprisingly, most of the recoveries in Madoff, based on where cash went, came from clawback claims, like the estate of Mr. Pickauer, I guess his widow had to pay in $7 billion or so in settlement. So one clawback claim produced $7 billion of the 11 recovered so far. Okay, but the point that I'm trying to illustrate is if you look at the economics of Madoff, you'll see a lot of the recoveries come from clawing back money paid to people who won in the scheme. So you put $1 in, you get $2 back. A trustee in bankruptcy can say, wait on, hold on there, at least put back the $1 of winnings you made, because we got a whole load of people who've lost $17 billion. So if you're up like Pickhours were of 5 or 7 billion, they had to put back the profits that they earned. Where'd the cash go in Stanford? 3.5 billion in general administration, salaries, rent, and commissions. As Eve points out, commissions you put in quotes, because a lot of money went to salesmen who perhaps knew or suspected that there was something spicy going on in the business. $2 billion was stolen by Stanford. If you go back to Madoff, it was, I estimated it based on what I've read, it was 200 million. So Stanford stole 10 times what Bernie Madoff stole, even though Stanford's fraud was 10 billion came in the door instead of 20. So the numbers change in terms of how much is actually lifted. We have redemption payments of 4.5 billion. The total net losses, again, in this case, are 5.5. Peters, 31 comes in the door. Losses to victims, only 2 billion. And look at the churning in Peters. Money's coming in, money's going out in a big circle. Round tripping, we call it. Rothstein, this is down here in South Florida. Chuck, you estimated that Rothstein, I said stole 40 million, and you said, well, he purchased cars and boats and stuff with the money.
Right, he spent about $40 to $50 million on things like diamonds and cars and boats and sports tickets and crazy stuff.
But still, it pales in comparison with Robert Allen Stanford's $2 billion. 40 million is nothing. So we have the centerpiece to these cases. We posit the hypothesis that there are two types of assets to recover in a fraud case. One are traditional assets, bank accounts, operating businesses possibly. Like in Peters, he bought the Polaroid. Remember the old Polaroid camera? Well, he bought that business and it had some value. There are hotels, there are other tangible assets, some intangible, traditional asset recovery. But when we're talking about asset recovery in large scale cases like this, I say that over 70% sometimes, or 80%, come from bringing proceedings either through clawback claims like in the Madoff case, which is the preeminent clawback insolvency recovery exercise, or in Stanford Bank where we're marshaling cases together against banks to impose a liability sounded in damages for the banks having to enabled or facilitated the fraud. So that's a very untraditional form of asset recovery. You show up as a new bankruptcy trustee, you attack traditional assets, but while you're doing that, you start to ask questions while you're tracing down the value chain as to who is responsible for assisting in the carriage of the fraud, banks, lawyers, accountants. So now it's clear that the function of the bank is central to a Ponzi scheme like Stanford or Madoff, because you have to collect payments from victims, process them, and steal money or make Ponzi payments back. And oftentimes we'll say, isn't it obvious to the banker who is facilitating these payments that there is no underlying genuine economic activity going on if all the cash is coming in and going out to pay payments like Peter, robbing Peter to pay Paul right under the watchful eye of a bank and its compliance department. So we say the bank had the greatest insight for payments in a fraud because they were executing the payments. There is nobody else other than the fraudster himself who has intimate knowledge of the payment history of the fraud than the bank itself and its compliance department. So we have also concepts like account nesting and correspondent banking that we had in Stanford, or the possibility of payment data stripping. When we do investigations looking at payments, we look to see, like in sanctions cases where bankers in Europe in particular have been caught stripping data from wire transfer payment instructions in order to fool other banks in the system as to the original source of the money. So if a payment's coming in from North Korea, which is sanctioned, a sanctioned nation, and a bank is stripping any data identifying or linking a payment to North Korea, what are they doing? They're knowingly participating in a fraudulent scheme to trick other bankers and compliance departments as to the origin of the funds. So look for payment stripping in our investigations. Now, this is the last background slide. The actual recovery of assets or value that has been accomplished so far in these 4 cases. Peters, you can see it's basically, I think, 1.5 billion or 2 billion of losses, and they've recovered about half. Stanford, we're not quite at $1 billion, we're about $500 million. Recovery is 5.5 to go, or 5 billion to go. Madoff, look at Madoff, where the target recovery is 17 billion, they've recovered about 11. An amazing result. Rothstein, it's about the same between recoveries and losses. It's a great success. So we need to develop facilitation liabilities, as I say, and we need to investigate facts that can frame actions. Now we're going to talk about how these actions are framed. The causes of action. Let's go through the panel. Now, Chuck, when you looked at the Rothstein case, you sped to the scene of the crime. Your client was appointed as trustee in bankruptcy. You start looking at recovery opportunities for creditors and victims. And when it came time to look at the banks and their facilitation of the case, how did you approach that analysis and that investigation?
Okay, well, first we were very fortunate in the Rothstein case in that my client, Herb Stetton, who's a somewhat legendary former judge down here, was appointed receiver first. And by his being appointed receiver, it made all the difference in the case, because under Florida law, if you're a receiver, it cleanses you from the fraud committed by the corporation so that you don't have an imperi delicto problem. And in the materials that I passed out to most of you, and those of you haven't seen it, there's a big package of materials up here everybody should get before they leave. I go through imperi delicto, and I give you the complaint and a memorandum of law that we filed. I'm giving you that background because what we did was we looked at the bank literally on day one, because we knew that from emails that we had acquired that TD Bank was complicit. I'm just going to spend a second and tell you some of the things that we pled in our complaint that would show you how they were different than most banks. RRA was a law firm. It was a, I'll call it average law firm. It was not an exceptional law firm. It wasn't that big either. Yet they had 26 accounts at TD Bank, 22 of which were called trust accounts, which is extremely rare for a law firm. And they had, in the course of a short period of time, $3 billion circulate through the bank. So they had a serious issue with understanding their customer, knowing your customer, and they completely abrogated that. And we had a list that we put into the complaint, and I'm not going to go through it because I could sit here and read it. It would take like 2 minutes long of the things that they didn't see. But what we did with TD Bank was we knew that if we put all of our resources into suing TD Bank on day one of the case, that all I would be doing is spending money getting that case together. So we pursued claims against everybody else, and then we took our time and carefully built our claims against TD Bank.
How much time did you have for limitation?
Oh, we had plenty of time. Statute of limitations was never an issue. So,
Ontario,
but it took us about a year to get the case filed, and I think it was the best year that we could spend, because by the time we filed the case, we had everything buttoned down, airtight. It's like if you've seen federal criminal indictments and there's a complaint by the Department of Justice that identifies some wrongdoing, you know that they have documents that back up every sentence, and that's pretty much what we did in the case. So that's what put us in the position at the end of the case of scoring big and getting a massive settlement from TD Bank, which is what made all of the Rothstein creditors 100% whole.
In the Rothstein Bank cases, isn't it true that TD Bank featured prominently, and that there were some really good facts fell out? How did those facts come out, and what were those facts that were perhaps more dramatic, more spicy than you usually see?
Well, what happened was as the receiver, we took custody of all of the RRA emails, and we segregated them instantly and started reading them and this is kind of a teaching point to the lawyers out there. I told my team that I didn't want to use buzzwords or keyword searches because we would miss too many things. So we literally, hand by hand, went through every single email. And what Rothstein did was he had set up a number of people inside the bank that he was effectively bribing, one of whom was a senior vice president for the South Florida region that goes to prison any day now if he hasn't already started his criminal sentence. And it would allow Rothstein to come into the bank and give a dog and pony show, and then Rothstein would pull up literally a forged screenshot of an account that would show that he'd have like $2 billion in the account when the account didn't even exist, or if it wasn't appropriate, if it was an account number, then he was just fabricating the number, and he had one of his IT guys that was plugging in the blanks. So they did that. The bank also gave what was called a lock letter. Now, I bet everybody here has worked with banks forever, and you've never heard of a lock letter, which was a letter to the investor saying that your money is locked in an account at TD Bank, and the only one that can get access to it is you. Well, there is no such thing as a lock letter. So that fact was extremely helpful, but a lot of it was on know your customer obligations, because you can't have a law firm that had revenue of, that was actually losing money as a law firm, had limited revenue that has $3 billion flowing through it. And on a monthly basis, the average flow was about $1 billion. So that was extremely helpful.
But I guess I interviewed or met, I know a hedge fund manager in New York who their fund lost $80 million in Rothstein. And they got sued at first because people thought that some hedge funds knew more than others and got money out before others did. And he had developed evidence that said that he was tricked by the TD bankers involved, that there were meetings that he had inside TD Bank where the TD bankers would produce so-called lock letters that tricked him into believing that $100 or $200 million was on deposit at Rothstein's law firm. So this is a very unusual case where you have hard evidence of one or two bankers inside a bank knowingly participating in issuing false statements in writing about how much money was sitting in the Ponzi scheme at the time. It's stunning.
On your last point there, Martin, it was really hard for any of us to accept that there were innocent investors in the Ponzi scheme, and that's because the Ponzi scheme was revealed October 30th, 2009, when the economy had crashed for all intents and purposes, and these investors that were investing in 2008 and in 2007, 2008, and 2009 until it crashed, were getting interest rates of, on the low end, and this was only a few deals, 15%. It was not abnormal for people to be getting 70% returns in that time period when everybody else in the world is getting 1%. And we had a lot of deals where people were getting 300% returns. So when they say they didn't know, we would look at them with a, curious look and say, how could you not know? Because there is no such deal as a 300% deal or 70% deal, and especially then.
But you had unique facts here where they could point to lock letters being shown to them saying, well, there's 100 or 200 million sitting in the account. And I appreciate it's a willing suspension of disbelief when looking at people's intentions subjectively and what's in their mind. But what we do know is that TD Bank in this case produced exceptional facts about conscious, overt participation in a fraud. This is very, very unusual. And when we get into the standard of review in the United States, I'm going to ask Gonzalo to talk about right now, is you've got different facts in Madoff against banks. It's not like Rothstein, right? So you've got what is your core theory when you're investigating and trying to sort out what the standard of review is. And I think in your case, Gonzalo, you're also looking at different jurisdictions and therefore different standards and different causes, right?
Well, by way of background, in the Madoff case, the role of banks is actually quite complex. And in terms of showing the numbers, I really struggled when Martin asked me to provide him with the numbers for the amounts stolen by Madoff, the amounts churned by the fund, because they're very difficult to discern. And a lot of these matters remain sub judice, so it's difficult to give concrete answers. The $20 billion figure reflects primarily what was left in principal that we can say was stolen by Madoff at the end. In terms of the amount that went through, it's difficult to discern because the way the Madoff fraud operated through a feeder fund system was that a lot of investors would invest in the fund, and redemptions would be funded by new money coming into the feeder fund before it hit BLMIS. So depending on how you look at BLMIS, that figure could potentially be in the many, many, many billions of dollars. At any event, it's far larger than that $20 billion figure over the life of the fund. But one of the key components for our case is where did that money come from? And this is one of the areas where the banks come in, which I'll get into in a second. The second area is the custodian bank for Madoff, which was JP Chase. And in there in the Southern District, unlike Charles, we had a real problem because we have a rule called the Wagner Rule in the Southern District, in the Second Circuit, which denies a trustee standing when he is attempting to recover funds in a liquidation stemming from a criminal fraud. The rule is the traditional impari delicto rule, which basically says you have unclean hands, you're standing in the shoes of a criminal, therefore you cannot bring causes of action against somebody that you can't bring causes of action that would have belonged to the company. What you're left with as a liquidator are the traditional causes of action, which are the fraudulent transfer causes of action under the bankruptcy code. So we had to proceed under that theory. It was frustrating for us, frankly, in the lawsuit against JP Chase, because to Martin's point, if you look at the JP Morgan account, which we refer to in our pleadings as the 703 account, 97% of the additions to that account were customer contributions. Roughly similar figure is monies out. Actually, it's about 100% monies out are redemptions. You don't see anything going to the DTCC. You don't see anything going to anything that would be associated with securities transactions. When we were looking at these figures for the very first time, I happened to be buying a house when I joined the Madoff team. And I went to the bank and I drew a check for about $70,000 for my down payment. And about 10 different phone numbers that I have got phone calls asking me why I was drawing a check for $70,000. So my thought was, all right, well, if JP Chase is looking at me pulling a check for $70,000, they damn well had people looking at what Madoff was doing. Why didn't they ever ask these questions? Unfortunately, those causes of action were lost to us under the Wagner Rule. The matter proceeded through a class action, was eventually settled in the Shapiro Hill class action settlement, which is you can all see on the Madoff website, and it's publicly available.
But there was a regulatory proceeding, right, that churned out some money for victims?
Yes, yes. And the way the money is distributed, monies that went through that process didn't necessarily come into the BLMIS estate, so we're not responsible for that distribution. But that actually doesn't end the story for the banks. The banks play an extremely important role in the Madoff case because to sustain a fraud of that size, you had to look for how Madoff accessed these monies. There were, in particular, two banks in particular. If you look at our allegations, we allege that HSBC and UBS were responsible for directing billions and billions of dollars into the fund. And through our investigation, since we're limited to bankruptcy causes of action, we've had to trace monies going into those estates through the fee process. So as money went into, as money came out of Madoff in redemptions and they took their percentage fee, that's the money we're going after. But what's even more interesting is because these banks all provided the services for the feeder funds, which were essentially shell entities, our theory of recovery against the feeder funds is all based on the knowledge held by the banks. This is where the know your customer rules come into play, the due diligence processes involved by the banks come into play. And we've launched a very, very extensive investigation into what the banks knew and what they didn't know.
Because these public law duties now, we have in the last 20 years developed, right? Mm-hmm. They require the bank to know something and to have systems in place to know.
Well, and what's even more important there is that in the context of these class action lawsuits by investors, the banks have said that they did this diligence, that they looked into these things. Well, our response to that is if you look at the Madoff numbers, and what's extraordinary about the Madoff case really is not is not the sophistication with which it was executed. It's how basic and simple it was. It was basically just fake account statements and poorly executed fake account statements. It was a collared investment strategy. So it was securities basket that tracked the S&P 100, collared by put and call options. If you look at the statements, half the time the trade tickets had the put and call options reversed. So if he was buying when he should have been selling, selling when he should have been buying. He's executing more options than exist in the market. I mean, it was a very, you know, I'm not going to say it was a poorly executed fraud, because obviously it got quite far, but it was not hard to spot, and in fact, lots of people spotted it. So when you have a bank stepping up and saying in a class action context, well, we looked at all this stuff, well, the response is, well, if you looked at all the stuff, you had to know. These aren't small investors. These are not unsophisticated investors. Trading more options in a day for a single customer than exist on the entire Chicago Board Options Exchange is a pretty big red flag.
So the standard of review in New York, though, is pretty high, right? You have to show what to sue a bank in one of these cases?
Well, in our cases, it's not just the banks, but in our cases right now in the SIPA proceeding, the standard for recovery under the bankruptcy code is to recover 2-year transfers in light of the safe harbor, we have to be able to show willful blindness, which is roughly the same standard of conscious avoidance. To recover 6-year transfers, which is the application of the New York debtor-creditor law, we have to be able to show actual knowledge of fraud. There's going to be quite a bit of litigation as to what actual knowledge of fraud whether it's actual knowledge of the fraud or actual knowledge of fraud and knowledge that no securities were being traded.
But those 2- and 6-year look-back periods, you're talking about clawback claims.
These
right?
are clawback actions.
Yeah,
we're not able to
bring
bring
the
any
case
other
against the
causes
bank.
of action.
But let's just assume you didn't have the standing problem. Okay, let's just assume you're just a regular trading company, you're a trustee for a trading company, or let's say an individual victim, right? You still have the same problem with the trustee in bankruptcy. Any trustee in bankruptcy in New York?
If you're not a liquidator in that context, you might have the ability to bring lawsuits under common law theories, but you're not going to be able to because any liquidator is going to stop you from bringing those lawsuits.
Of course.
So what winds up happening is during the term of the liquidation, it effectively cuts off that avenue.
But you don't. What you're saying is, in New York, you don't even get out of the gate in an insolvency case against a bank.
Not in a criminal fraud.
Because of the nature of the standing rules.
Right, because of the Wagner rule.
So we don't even get to standard of review.
Correct.
But in the United States, generally, Chuck, what is it? You have to show to sue a bank what elements in the cause of action that you would typically bring, aiding and abetting, conspiracy.
Yeah, our case was moved into bankruptcy court only 2 months after the receivership, and that 2 months was enough. So our bankruptcy counts included a myriad of common law claims that Gonzalo was not able to plead, and those included breach of fiduciary duty, and we were able to establish that because of the relationship between TD Bank and RRA, there was fiduciary duty. Normally, it's very difficult to establish that a bank owes a customer a fiduciary duty. But we pled that in detail. We pled aiding and abetting, we pled conspiracy, and then we pled all the traditional clawback claims.
But don't you have to show something? The core of the case, though, is overt participation with actual knowledge of the fraud.
Yes, and in our instance, we were able to we knew that we could establish actual knowledge.
Would you agree with me? That's a very high standard. You need special facts usually. Not just that the bank may have failed negligently in compliance rules, but they had actual knowledge.
Well, we were able to establish the lock letters, the fact that they let Rothstein use the offices, the screenshots, the volume of
Sure.
the flow of the money was really important to us.
But
and then there were all these other red flags that enhanced the knowledge basis.
Well, you had bankers issuing false letters. They were in the fraud, okay? They were hookers. They were bribes being paid, right?
Yes.
It's a special fact case, is Rothstein. I want to get at a case that's not like Rothstein. It's more like Stanford.
Rothstein was definitely unique, and if it wasn't so unique, I don't know that we'd have gotten 100% recovery, but it fortunately was.
Let's go back to the basic case that most of us have to deal with, where we don't have hookers and bribes going into bankers issuing false letters.
Well, that's
right?
a shame.
Okay, let's just look at the normal case where we're saying there's been a terrible breakdown in compliance. I'll tell you, under English law in the British Virgin Islands, an English silk would say to sue a bank in the High Court of Justice in London is a very difficult thing because you have to plead with specificity the name of a banker or of a compliance officer, someone with sufficient seniority to have made risk decisions on the file, to shut the file down, the account down, and report the suspicions to the authorities. And in order to do that, you have to show something that would put an honest man on their duty to inquire. So you need specific facts that would show that an honest person wouldn't have turned a blind eye. And we have this concept of willful blind eye knowledge of the obvious. I think American lawyers in criminal cases refer to as conscious avoidance of reality. And what Gonzalo told me in preparation for this session was stunning. In this country, a person can be found criminally liable in a context like this. A banker could be found criminally liable for conscious avoidance of reality or risks, whereas in a civil lawsuit for victims for damages against the bank, that isn't the standard. It's the one that Chuck just spoke. And I just can't understand this.
So maybe this is helpful. I had a case in Miami-Dade Circuit Court in their business court, which is where all the complex litigation goes. And I was defending a bank on know your customer violations. And at about the midpoint of the case on an issue dispositive motion that was brought by the plaintiff against the bank, the issue was exactly that, what standard of knowledge would have to prevail in order for the plaintiff to win their case on a know your customer violation. And the judge ruled that if the facts were sufficient, that there was clearly a violation of know your customer responsibilities because it's statutory and they're set to this standard, that he was going to probably find that the bank had guilty knowledge because they should have known what was going on. Now, as it turned out, we won the case because we were able to put together an evidentiary record that showed that they didn't have the knowledge and that it was misstated by the plaintiff. But the judge's comments were pretty prescient, and we had a lot of pressure from the client to potentially settle, but we fortunately
Chuck,
didn't.
We're going to move over to the Canadian standard review now with Link, but before we do that, to finish the English one, not only do we need to have fixed in the pleading a specific charge that a specific person had actual knowledge sufficient to be constructively dishonest by failing to take appropriate action upon having possession of specific facts that would put an honest person on a duty of inquiry. If we don't have those to go into a pleading, we get it struck out, right? And oftentimes the only way to show that the emperor has no clothes is to get into disclosure, or we call here discovery, because that shows what the bank actually did in terms of compliance or didn't do, and will oftentimes turn up facts to show you hit the standard of review. So the problem with litigating against banks in London is a pretextual one. You need to have the case built before you get to go to discovery. And if you have no investigative means to get access to what's inside the bank, you've got a big problem. Now in Canada, we're going to get into what the standard of review was for us faced there against a big bank, because it's slightly different, but it's generally the same in a knowing assistance context. But the way to defeat that, in my view, that problem of pretextualism, having to know everything when you don't have access to the information inside the bank's compliance department, is to interview witnesses. Stanford Bank was a case that ran for 18 years. There were men and women that had worked on the file inside the bank we were proposing to sue for many, many years, some of whom had retired. We interviewed 52 people before starting the proceedings, right? And some of those people provided us with sufficient particularity of facts where we could beat a motion to strike. Link, why don't you talk about in Canada now, under Quebec law and Ontario, the different causes of action we have in negligence or knowing assistance, and how they might be different in Canada in terms of accessing those lower standards of review.
Well, it seems the real problem is the difference between Toronto and Fort Lauderdale is we're not nearly as colorful as the frauds down here. So our fraud is much more vanilla and just as complex, but that we don't have the lock letters or the extreme circumstances in our case. So the case we're running would be the biggest asset in Stanford estate right now. And it's going to be a complex commercial case built not on lock letters, color for people, jewelry, and that type of thing. It's going to be built on what we hope will be the lower standard, which we can establish, which is not just knowing assistance. And the way Chuck has described it with the levels of knowledge and willful blindness would be very similar to what we would have in Ontario. And so you need, a lock letter or, those extreme examples. The other cause of action we have in Ontario available to us when we're pursuing for liquidators, so the former customer of the bank, is negligence. So you can actually use a lower standard and in the case. So it's not, you don't need the lock letter, you don't need actual knowledge, you don't even have to go to willful blindness. We would plead all of those and run that case as well. And Martin said, we're interviewing.
Well, so long as you get lucky, right? If you're acting for the estate, you got to get lucky, which is the bank failed to protect itself by getting the customer to sign a disclaimer of negligence liability. Whenever you open up a bank account, look at the back of the mandate card, and typically it says, I agree that should I lose any money through the operations of the account by the bank shall not be responsible unless they are liable in gross negligence, which is recklessness, which is a constructive form of dishonesty, or willful default, which is another form of dishonesty. So usually, by contract, bankers in Canada and the United States and elsewhere contract out of negligence liability as to the customer, but not as to third parties. And sometimes you can plead the case with sufficient detail to show, that it was reasonably foreseeable that the bank could cause injury to non-customer victims of a fraud, in which case a duty of care might be fixed in favor of victims, and victims don't sign disclaimer letters or mandate cards, so they won't have that defense of a contractual disclaimer if they sue a bank in Canada. I think there are a couple of cases in Quebec where third-party victims have been successful in Ponzi scheme cases.
And
even
in other jurisdictions. So that Martin's point there is who's the plaintiff. So in the case we're running, the plaintiff is actually the former bank customer, and actually in our case, apparently the bank has not disclosed any such limitation of liability letter.
They just made a mistake.
Yeah, the bank never got Alan Stanford to sign an operation of account agreement.
Until the last 2 years of 18 years.
So we can run a negligence case, and the negligence case in our jurisdiction is like running any other negligence case. Did the bank act as a reasonable bank in the circumstances? And we've heard from the previous speakers is what is the standard? And it's become the AML legislation, international AML legislation is setting the standard for bankers. Bankers are now required to know more about their customers than they did 30 years ago. There's no showing up, you're not supposed to show up with a bag of cash anymore. You're supposed to know about your customer's business. The more you know helps you in your actual knowledge cases, but it also helps in your negligence cases because you're not so interested in what they knew and didn't know, you're interested in whether they fell below the standard to which they're supposed to act and didn't find out. And in doing so and letting the business continue, become liable in negligence.
So ergo, in a negligence action against a bank in a Ponzi scheme case, I would posit the view that A, if the bank didn't do anything, they're negligent because they're not fulfilling the standard expected of them under public law duties to know their customer. So if their answer is, we didn't do any due diligence, so therefore we didn't see anything as being suspicious, liable for negligence. Two, if they do some due diligence, like in Stanford, we've alleged 22 trips to Antigua, some appearing to be some kind of boondoggles, not asking the right questions, and juxtaposing how compliance functioned at TD Bank compared to some other banks. That's a big part of the pleaded case that we've constructed. Mr. Stanford tried to get correspondent banking with many banks in America and was either told to go away when he tried to open an account because compliance at those banks functioned as intended, or he went to some banks like Bank of America, banked him for 18 months or so, and you could see a war inside the bank between compliance and the business people, and eventually compliance won, and out he got toffed on his ear. It was critical to the lifeblood of the fraud that he maintain a correspondent banking account, because that's the window to the payment system. Absent that, he can't take victim money. He can't make Ponzi payments. And so why, in our case, we say, why go to Toronto, where you've got US dollars coming from 140 countries and 22,000 victims, 70% of whom are from Mexico, Venezuela, Colombia, high-risk money laundering jurisdictions.
I'll leave it on this, and then we'll move on topics. But the best facts is we put in our pleading, which don't get near what Chuck has got in his pleading. But we say a former bankrupt gym owner from a small town in Texas running a bank out of Antigua has decided to run billions of dollars through a Toronto bank.
In US dollars.
In US dollars. And why would you do that?
Because we say, and the facts seem to show, that U.S. bankers had a better game of compliance than our Canadian bankers were effectuating through these years. Over to you, Yves. Now, we've got a completely different perspective from Yves, dealing with the civilian legal tradition in the great continental civilian legal systems, you know, Spanish civil, French civil, which is Yves' concentration in Geneva, or German civil. And Yves, when we're looking at banks in fraud cases in Switzerland under your version of French civilian law, how do we construct investigations, and what's the standard of review we're facing?
Okay, first, how do you establish your facts? We have an almost inexistent discovery process in civil proceedings. So if you want to actually build your case, and you have also in civil proceedings an obligation to have as complete a fact set as possible. So it is very difficult to add facts after the beginning of the opening of the case. So because of those two difficulties, the way we proceed in fraud or other similar cases is that we first bring criminal proceedings or join existing criminal proceedings in which we participate as representatives of the victim of the crime who has legal standing to participate as civil plaintiff. So during those criminal proceedings, we can obtain evidence, production orders issued by the prosecutor against the bank, obtaining all internal notes. Exactly, I would say, in the same way, in the same generic way, you can obtain documents through common law discovery. We can participate in the examination of witnesses and suspects, ask them questions directly, or ask the prosecutor to make such questions. We can also request the prosecutor to issue letter rogatories to obtain evidence from abroad, because very often the evidence regarding the underlying offenses is not necessarily in Switzerland. It may be in another jurisdiction like the USA or Antigua and Barbuda in the case of in the Stanford case. So essentially, because of this gathering of evidence process, we first need to find crimes that we can attribute to persons who acted in and from Switzerland. So we will look into whether the bank may have been complicit of the Ponzi as far as the elements of fraud or embezzlement or criminal mismanagement. In some cases, the corporate entity that was used to run the Ponzi scheme was a client of the bank, but in addition, the bank might have held also an account in the name of an offshore company beneficially owned by the owner of the corporate entity used to run the Ponzi. And you would have movements from that account to the other, or from other accounts of the corporate entity to this offshore company. So those also allow to bring criminal proceedings for money laundering, and we have case law according to which the victim of the predicate offense is also considered to be the victim of the acts, the subsequent acts of money laundering. So this process, which will take very often years, sometimes concludes by a trial, but very often either due to statute of limitations or to the fact that the main defendants are not necessarily in the country, we are left with the evidence that we have gathered during that process, and to go before civil courts to bring our action in damages against the bank and or the bankers. And there we have two possible causes of action. If we represent, let's say, the corporate entity that was run that was used to run the Ponzi scheme, who was a client of the bank, then we can sue the bank for breach of contract. And essentially, there are not many differences between the tortious action committed by the bank and the breach of contract, but the difference will be that in a case of breach of contract, the negligence will be sufficient to...
Is there an implied duty of care in the contract?
Yes,
customer and
there is,
banker?
and there is a duty by the bank to of course, to comply with all obligations. You shall not steal, you shall not...
So in terms of investigation, so you use the criminal process to get access to the records, right?
Correct.
Why? Because we could be the partie civile, the party in the case?
Absolutely. So you
The victim.
Yes, exactly. As a victim, you assist the prosecutor in conducting his investigation, and
Now, I think I can refer to something called the proximal report as an example, because it's attached to our Ontario Statement of Claim. This is a report that was written, and what's salutary about this is you need to, in these cases, when there are multiple banks, consider investigating how each of them perform, like I alluded to earlier. And you'll see some compliance perform as intended, and some are reasonably well-performing, and others are just terrible. And that helps to prove what the standard of care is, or how the bank misbehaved, if it did, by looking at how brother banks or sister banks behaved on the same facts in the same case. Here's an example. I was entitled to do an inspection of some records that were going to be sent to the U.S. Department of Justice out of Switzerland on behalf of the Stanford estate. And lo and behold, we found a little report in the compliance files of a Swiss bank. The report was written by a small investigations firm called Proximal out of Great Britain, which was a sole practitioner investigator, former Scotland Yard detective. And we interviewed him under Section 236 power in England, and he produced some records. It showed he charged £500 and produced this report in one afternoon's work of due diligence in the year 2000, in September 2000. This is almost 8.5 years before the fraud was openly discovered and shut down, okay? What did the report say? It was about 10 pages long. It details Mr. Robert Allen Stanford's background as it was then known in the public domain and through some checking with law enforcement on the phone in the course of an afternoon. And it laid out and displayed the fact that Mr. Stanford had been facilitating money laundering for the largest drug cartel in Mexico called the Fuentes Gang, and that the DEA had intervened on a bank account of Stanford Bank in Florida and seized $4 million of proceeds of narcotics trafficking in the year 1998. In the year 1999, he arranged to put himself in charge of the Banking Regulatory Commission so that the regulator would be himself regulating himself, right? A little bit of a conflict of interest. That the U.S. Treasury Department, quote, freaked out when this happened and warned anyone from doing banking with onshore with Antiguan banks, because you had Mr. Stanford being the chairman of the Banking Regulatory Commission. And yet all these facts were displayed at a cost of £500, an afternoon's work by one investigator, and his conclusion was, in the opinion of this investigator, if this bank, my client, continues to do business with this man or his banks in Antigua, and should a problem arise in the future, I can see no objective way with which you could defend yourselves through civil liability, criminal liability, or your reputational capital, period, the end. Signed by an investigator. That's called a loaded gun inside a compliance file, where 8 years later we find the second largest Ponzi scheme in world financial history was going on. And this investigator, for £500, found the facts needed to put an honest person on inquiry and to shut the fraud down.
Yes. So getting back to the causes of action, this document, for example, would have had been would have normally triggered a requirement under the Swiss anti-money laundering law system that the client should be put under enhanced surveillance so that the economic background of the transfers should be should receive better explanation. And under our Swiss system, failing to take those steps can be qualified as a lack of adequate organization, which is a breach of both the Swiss Banking Act and of the Swiss Criminal Code whenever crimes are committed due to this lack of adequate organization to prevent crimes from being committed within the bank. So those are also in themselves causes of action and do not require an intentional conduct, but simply the mere fact of abstaining from taking the right steps to implement the anti-money laundering procedures within the bank is also a source of liability for the bank.
On last point on investigations, particularly in a red flag-oriented case going over 2 decades, there are people well trained in this, going back into the deep internet into 20 years ago. One lady is Cynthia Hetherington. She puts on seminars for CIA agents to work the deep web. And in one of our cases, she constructed a report showing all the red flags that existed dealing with Stanford Bank going back to 20 years in horrendous detail, showing exactly what a reasonable person could have found on the internet over the last 2 decades preceding the discovery of the fraud. So it's very important that public information can help to plead the case as well. So now we're moving on to defenses. And the 2 big ones are ex turpe causa in the English or Canadian style of it, or in peri delicto. These are ancient Roman Latin terms for an ex turpe causa's case. The law will not recognize a suit based on an illegal consideration, or in peri delicto just simply means of equal guilt or fault. So the idea is that if a fraudster has used a platform for fraud called a company or a bank, and it goes into insolvency, we appoint a liquidator to help the creditors recover value, right? And the problem is, legally, is how does he do that if the company itself could be said to be a wrongdoer, a fraudster itself, because it was used in the centerpiece to the execution of a plan of fraud. And so in the United States, it seems that you've developed this notion in sort of a, I don't know, I wouldn't want to say authoritarian sense, but an extreme sense where judges have concluded that, well, it just simply means that no receiver or trustee in bankruptcy can sue a third party in the name of the insolvent enterprise because it itself is a wrongdoer and the law will just not recognize it as a plaintiff. I mean, and although this is being chipped away at and there's some reform in case law, this is a big problem in these cases, right, Chuck?
It was one of the reasons why it took us a year to get the case filed, because we knew that in peri delicto would be the biggest defense, because it just stood out, because Rothstein was such a notorious fraudster who had, at least viscerally within the law firm, acting on his own, even though we knew from day one that there were other co-conspirators. That created other problems. So what we did to put together our complaint was to interview an awful lot of people, and one of the biggest things that we focused on was the sole actor exception to the adverse interest rule, which is that we were able to establish that there was this management committee that Rothstein had created of senior partners in the firm, and that most of the lawyers that were on that committee were also taking bribes or getting other crazy inducements, like getting a free Maserati for no good reason, or having a wing to their house built onto it, or literally a $5,000 a week allowance for hookers, or I can go on and on and on. But we did have one person on the management committee that never received any inducements, and we interviewed him, and we were pretty convinced that This person did not know the fraud was going on. Now, clearly there were red flags within the fraud that common sense would have said what's happening in this firm doesn't make any sense. But we felt, at least for purposes of Rule 11, that we had a really good faith argument that he didn't legitimately know. And we knew that there were a number of lawyers, there were about 83 in the firm, and we knew that probably 60 didn't know what was going on. Now, if you think about it, 23 fraudulent lawyers in a law firm is a lot. But that was one of the foundations for our being able to try to defeat the imperi delicto rule. And we actually started writing briefs in opposition to motion to dismiss before the motion was even drafted and served on us, because we knew where they would be coming from. And imperi delicto is really critical in all these cases.
It's probably worth pointing out that the Wagner rule in the Second Circuit is the Second Circuit rule. It's not applicable in other circuits. So if you have a choice of forum to where you want to start your liquidation, you might not necessarily be hampered. There are, excuse me, there are circuits in the United States. Chuck, you probably know better than I do, actually, which ones those are. But there are circuits in the United States that do not impute that wrongdoing to a trustee. And another important thing to remember.
Yeah, I actually haven't seen that. I've always seen the trustee as it imputed to.
And there's in addition to the adverse interest rule, another potential way around it is to seek a contribution claim. That if you can always embrace the fact that you're a wrongdoer or that the underlying actor is a wrongdoer, and seek contribution for the wrongdoing, as you could in an ordinary common law contribution claim.
Now, under English law, we've had a controversy in the last 7 years or so with extirpe causa. It's swung from being forgotten about, a lost relic in the mists of time of English legal history, to a case called Stone and Rolls, which revived it. And in Stone and Rolls, a fraudster stole about 25 million pounds from a bank, and he used a company to perpetrate the fraud. He hired Moore Stevens, I think in the Channel Islands, to issue audit opinions based on audit reports, based on management accounts, which were phony. Moore Stevens got sued by the liquidator on behalf of the bank creditor, and Moore Stevens defended on the basis that, look, this was a single man company owned by a fraudster, dominated by a fraudster, was an extension of the fraudster. All actual knowledge of the fraud can be imputed to the company. That means the company itself is up to its neck in the fraud because it was just an extension of the fraudster himself. And on those special facts, the courts in England struck out the claim against the accountants for negligence, and they were pretty obviously negligent, so that the creditor bank was deprived of remedy by reason of this medieval notion. And then we go backwards in time, or forwards in time, to a case that came out 1 year ago from the Supreme Court of the UK, narrowing Stone and Rolls, because it started to be used in various, the law of unintended consequences. It was being used everywhere by defendants in every situation to avoid responsibility. Directors were using it in their defense, and a director liability case went up. Can you imagine a director dishonest and defending himself of his dishonesty by saying the liquidator can't sue me because I made the company dishonest because I used it as my instrument? It was going in a big circle, and the Supreme Court said, look, we're going to take Stone and Rolls as a relic itself, and we're going to set it aside and start again. And it seems there were like 5 or 6 judgments. They're a bit conflicting, but if you read the judgment, it goes on for over 100 pages. It looks like the state of the law in the UK now is that if you can find a single executive or someone of sufficient seniority in an enterprise that was perpetrating a fraud, who, had he or she known of the fraud, probably would have reported it and stopped it to the extent they could, then you'll beat the defense of extirpe causa. So we just need one person we can find. It was funny, I was in the board of directors of a major Brazilian company recently, and they all started laughing when I gave them that test, wondering, could we find an honest man here? In any event, what we know is that link in Canada, I think, again, you've got a more moderate view, and what in a case dealing with a corruptly managed theater company called Livent, I think, the Ontario Court of Appeal has really sort of smashed away at this kind of defense, right?
Right. So a receiver bringing a claim in the name of the company against its former auditor, extra because it was a major defense. And what the court has said, that in the highest court now in our province has said that it's a policy-driven rule. So if it's a receiver or a trustee or a liquidator, and all of the proceeds or the damages are being paid are going to flow ultimately to the creditors, so not to the company or any of the individuals that benefited from the wrongdoing. From a policy perspective, extra because defense ought not to be successful, because from that perspective, the money isn't going to the wrongdoer, it's going to the creditors who had the wrong committed against them. So from a broad policy perspective, the law in our jurisdiction now is with respect to extra because the law still is, in some other cases, you can look for the sole actor, you can look for those types of things, but our highest court has now endorsed this policy perspective, which makes the defense of extra because much more difficult to bring successfully, especially against a receiver or a trustee. Or
And in the same case, didn't the Court of Appeal of Ontario smash away at contributory negligence in fraud cases?
That's right. So also on the same theory, that you're actually the actor that is the plaintiff is flowing the funds out to the creditors, and the people that had the wrong suffered the wrong.
Yves, over to you. Defenses in Geneva, or the Canton of Geneva in suing a bank, a moment on defenses, and then a moment on damages, which I think are our biggest mountain to climb in Switzerland.
Okay, we don't have a defense such as extra because in pari delicto. However, if the victim of the damage has by his or her behavior contributed to the surveillance of damage, this may be a cause for reduction of the award in damages. So it is not a defense per se, but a cause of reduction of the award. However, if we go back to a Ponzi scheme situation, the behavior that is reproached to the bank is precisely going to be to have disregarded signals that the owner or the manager of the Ponzi scheme was acting in breach of his duties towards the corporate entity. So in that case, the bank will not be able to oppose this exception or this cause of reduction, because it is precisely the behavior that is being the cause of action against the bank. Getting now to the issue of the quantum of the damages, we have no tradition in Switzerland of big awards against banks or others. That is, but also shocking. But in general, I would say that it is not only the banks. It's in general we don't have very big awards for damages.
Is this because your magistrates at first instance are literally country farmers and people like this who are not legally trained?
That's what some people might say, but I refuse to give any credit to those explanations. No, essentially our principle for the calculation of damages is that there is an element of preservability for the author of the damage as to how much, more or less, what would be the consequences of a breach of his or her duties. So very often our causes of action are not necessarily going to entail that the bank was fully complicit in the Ponzi scheme itself. It was just a contributing element to that. So very often you will have a limited possibility of.
So you're able to apportion fault. You don't do joint and several liability in the notion.
That's correct.
If there were 5 bad banks in one case, you would just say, well, what is the role of this one bank?
Absolutely.
And if it only handled a small fraction of the money, then they only might be liable for that.
Correct.
But link is different in Canada. Wouldn't you say that the notion of joint liability is probably more prevalent than separating it?
That's right. So we certainly have joint and several liability, and a question in these types of cases with respect to the damages is whose damages are you pursuing? So in the cases we've been talking about, the plaintiff is the former customer of the bank, so you're acting for the receiver or the liquidator. And a defense can be, well, the actual entity, so Stanford International Bank or the law firm, actually suffered no damages. It's actually the investors or the creditors that have all of the damages. So whose damages are you trying to recover? And so that's a potential defense, but the response to that is that the entity, so the liquidator or the company in liquidation, it has suffered damages and that it can no longer pay its creditors. So if you have, as we have in Stanford, creditors seeking $5.5 billion, they're out the money for sure, but it's Stanford International Bank in liquidation that is unable to pay its creditors and therefore has the damages that we're claiming.
Yeah, ergo, it's a debtor, and it needs to come up with money to pay its debts.
Right.
Gonzalo, over to you with respect to damages theories and suing banks. Is it just the normal, what the proximate loss may be occasioned by the breach?
Well, again, in our cases, we're limited by actual losses because we can't because we are limited to the clawback actions. And in addition to that, the way in which we've calculated the net equity losses in the estate are that we don't include book value or the statement value in the damages. So essentially, our damages claims are capped by the actual losses of principal.
So you mean the cash in, cash out method of accounting?
Exactly,
So
exactly.
you restate the Ponzi accounts.
Exactly.
I think we all do that in
Right.
all of our cases now.
But what's interesting is that we have, in one of the ways you can deal with in pari delicto, one of the ways you can deal with the damages issue, we have reached agreements where we'll settle a case with a feeder fund and allow the feeder fund to pursue claims against the bank, and where, especially where the feeder fund itself is in liquidation or has limited assets, and we'll take a sharing percentage of their causes of action against the banks, which can be brought for statement value. So it actually increases the amount of damages they can recover. We get a portion of that comes back into the estate. So it is a way of trying to get some of those recoveries that have been cut off. We've had to do reach some creative agreements for that.
Chuck, what about damages in Florida in suing a bank? Are there any special issues, or is this normal damages theories?
What we did is, when we looked at damages, it was broken down into various components. We had some statutory claims against TD Bank as it pertained to money that they received that we claimed there was no reasonably equivalent value for the funds that they received, and those were all sorts of fees. Then we had liability for them for wire transfer and negligence liability, and that's because they allowed Rothstein, and this was a great big red flag, by the way, to have, the number's going to be wrong, but it was pretty close to $20 million in overdrafts. Now, if you're a bank and you have a law firm with 20-some trust accounts and you've got $20 million in constant overdrafts, you've got to be looking and saying what's going on. And we actually had a claim there for wire transfer liability, and then the rest were based on our common law claims that I discussed earlier.
Very good. I guess we've come to our time, and I'd like to ask, are there any questions of the panel? No? Okay, well, thank you for your attention. Oh, one question. That's a very difficult question to ask any lawyer. I would say there have been allegations made and findings. I think the comptroller of the currency, the comptroller of the currency has fined it first round for laundering drug cartel money from Mexico, like Mr. Stanford did 20 years ago. They had to pay $1.2 billion in fines, and then they had to spend $1 billion to clean up their act on compliance. And then the comptroller of the currency went in to see if they did a good job on cleanup, and then they were fined another $1 billion. So that whole round trip has cost $3 billion, I think, minimally. And now they're apparently got way caught up in the Panama Papers scandals. Some fellows at the BBC told me that the Panama Papers reveal that HSBC is up to their necks in problems with Panama Papers. Sorry? So, that would be data stripping. That would be hiding the identity of Iranian business people or organs of the state in order to violate sanctions. Yes, I think there have been allegations made in the Panama Papers about both Mossack Fonseca and HSBC violating sanctions by committing corrupt acts in order to strip data and hide who is behind the payments. Very good. Thank you very much. I think we should give the panel a round of applause.
If you didn't get the materials, they're right here on the third table in.